Thank you so much for joining me today. Today we'll be discussing the Small Business Owner's Guide to Connecticut Paid Leave. In today's agenda, we'll be discussing what is FMLA, what is CTPL, what are the qualifying reasons for leave, what do I need to know about CTPL and FMLA, some job protected leave process scenarios, just to kind of give you a feel for how some of these things can work, applying for FMLA and CTPL, and some additional resources. So what is FMLA and what is CTPL? Public service announcement, CTPL is not FMLA. So what is FMLA? FMLA stands for Family and Medical Leave Act. There is a federal FMLA and a Connecticut FMLA, and both have been around since the 1990s. Both laws allow eligible employees to take job-protected time away from work for certain family and medical reasons. The Family Medical Leave Acts are implemented by employers and regulated by the state and federal departments of labor. FMLA does not provide income replacement. Employers may choose to adopt policies to provide for income replacement during leave, continue to pay their employees their regular pay while they are out on parental leave, or require or permit employees to use their earned accruals like sick leave, vacation, or other PTO while they're out on leave, but they're not required to do any of these things. These are just niceties that some employers choose to do. The Connecticut FMLA laws changed significantly on January 1st of 2022. As some of you may remember, it was 2 years and 16 weeks over those 2 years. Now it is 12 weeks over a 1-year period. So FMLA, to recap, is the Family Medical Leave Act, and it provides job protected leave for certain qualifying family and health conditions. So what is CTPL? Well, CTPL stands for Connecticut Paid Leave. The Connecticut Paid Leave Act is a Connecticut law that creates a source of income replacement benefits for eligible employees who cannot work for the same reasons as FMLA. It does not provide job protected leave. The Connecticut Paid Leave Act is implemented by the Connecticut Paid Leave Authority, which is a quasi-public agency of the state of Connecticut. So to recap, CTPL provides income replacement during certain qualifying family and health leaves. So in order to have job protection and income replacement, an individual must apply for both FMLA and CT paid leave. So if you take a look at the center of the Venn diagram, this applies to most businesses with 1 or more workers in Connecticut. So at the left, we have FMLA, which provides job protection, does not provide income, and the eligibility is after 3 months of employment, and that's for Connecticut FMLA. If you take a look at the right, we have CTPL, which does not provide job protection, does provide income, and the eligibility is based on a minimum earning requirement and employment status. So let's talk about the qualifying reasons for leave and the benefits. So we have medical leave. So this is the most common for treatment of one's own serious health condition. Okay, and this includes serving as an organ or bone marrow donor and pregnancy. Bonding leave. So this is to bond with newborn or newborns or a newly placed child, or for the time needed to process adoption or foster care placement. So this applies to both parents, can be used anytime during the 12 months after the birth or placement, applies to birth, adoption, or foster care. Okay, so this is very broad. Caregiver leave, to provide physical or psychological care or comfort to a family member who's experiencing their own serious health condition. Military caregiver leave. This is to care for a family member in the military who has experienced a serious injury or illness that occurred in the line of active duty in the armed forces. Qualifying exigency leave, to engage in certain activities arising from the fact that a spouse, child, or parent on active duty has been notified of an impending call or order to active duty in the armed services. And then there's the Family Violence Leave Act, and this is the newest here in Connecticut, and it's job protected time off, which can be taken by a worker who's a victim of family violence. And this would be to seek medical or psychological care or counseling for physical or psychological injury or disability, obtain services from a victim services organization, relocate due to such family violence, or participate in any civil or criminal proceedings related to or resulting from such family violence. And this is up to 12 days in a calendar year. So let's talk about a serious health condition. Okay, what does that mean? A serious health condition requires both incapacity and treatment by a healthcare provider. So examples of this would be an overnight stay in a hospital, a chronic condition for which you see a healthcare provider at least 2 times a year, or a long-term condition for which treatment is no longer effective. This would be Alzheimer's or terminal cancer. Incapacitation during pregnancy. This could cover prenatal appointments and complications during pregnancy. So let's talk a little bit about Connecticut paid leave and COVID or MPOX. So can a worker receive CT paid leave benefits if they have been exposed to or diagnosed with one of these illnesses? Well, simply being exposed to or diagnosed with COVID or MPOX or a similar illness is not necessarily considered a serious health condition. The worker may qualify for benefits if they meet the definition of a serious health condition, such as needing an overnight stay in a hospital or medical care facility, or being incapacitated for more than 3 consecutive days and requiring the sick individual to receive ongoing medical treatment, or resulting in or worsening a chronic condition that requires treatment by a healthcare provider at least twice a year. So we're going to shift a little bit. Let's talk about FMLA. So the primary difference between caregiver leave under federal FMLA versus the Connecticut laws is the definition of family member. So under federal FMLA, an employee can take leave to care for a parent, spouse, or child who is under 18 or is over 18 and has a disability. Under the Connecticut laws, an employee can take care of leave and receive benefits for a parent, spouse, son or daughter of any age, a sibling, grandparent, grandchild, or an individual related to the employee by blood or affinity. So let's talk about what that means. What does related by affinity mean? Well, that's any person with whom the worker has a significant personal bond. That's one of like a family relationship. So this is situation specific, and it depends upon the circumstances of the individuals involved. So examples of this would be an aunt or uncle who relies on the worker for unpaid care and has maintained a strong and enduring relationship with the worker, as typically seen between parents and their children or siblings, or an unmarried significant other of the employee with whom the worker has maintained a familial spouse-like relationship despite their lack of legal relationship to each other. So what do you need to know about CTPL? Well, am I covered by CT paid leave? So first we need to talk about, well, who's a covered employer? That's pretty easy. Almost all employers who have 1 or more people working in Connecticut, okay? And even the state of Connecticut as to non-unionized employees. So who's not a covered employer? Well, that's the federal government, municipalities, and local regional boards of education. I'm going to pause, unless those 2 groups, unionized employees, collectively bargain to participate, okay? And then non-public elementary or secondary schools, railroads, governments of other states, and other sovereign nations. Excuse me. And then, of course, I always have one timer that I forget to turn off. And then we have a couple other groups, some other non-covered entities. This is interstate truck drivers who work in Connecticut but live in another state, so they don't pay income taxes here. And then spouses of active duty military members who've opted to continue to pay taxes in their home state instead of where they're currently deployed. So other exceptions are sole proprietors and self-employed. So I am going to quickly touch base on that because I'm sure that there are a few of you here. So sole proprietors and self-employed individuals may choose to opt into the Connecticut paid leave program for themselves, okay? So to cover this, the individual must reside in Connecticut in order to participate. The coverage will begin on the first day of the month following 3 full calendar months after the person enrolls with the authority. If they opt in, they must remain in the program for a minimum of 3 years. They contribute 0.5% of their self-employment income as defined by the IRS. A sole proprietor who has employees may choose not to opt in for themselves, but they must withhold and remit their workers' contributions. And if you receive a W-2, you are considered an employee under the law, and you must participate in the Connecticut paid leave program. This is true even if you are also the owner or officer of the company, okay? So am I an eligible worker under Connecticut paid leave? Well, the worker must earn at least $2,325 in the highest earning quarter of the first 4 of the 5 most recently completed quarters from one or more covered employers in Connecticut, because some folks work more than one job. So this also includes, is the employee currently employed by a covered employer, and or were they employed by a covered employer in the 12 weeks immediately preceding the claim for leave? And just to note, the CTPL leave authority, not the employer, makes the eligibility determination. So how long can one receive CTPL benefits? So an eligible worker can receive up to 12 weeks of income replacement benefits in a 12-month period for all leave reasons, including military caregiver leave, except only 12 days of the 12 weeks can be used in connection with family violence leave. And an employee may receive an additional 2 weeks of CTPL benefits for a serious health condition resulting in incapacitation during pregnancy. So let's talk a little bit about responsibilities. First, we're going to talk about the contribution, CTPL contribution. So the worker is contributing the 1/2 of 1% of their income. The employer has, we hope, has already created their Connecticut paid leave account. They're deducting the 1/2 of 1% of their employees' wages up to the FICA limit, Social Security contribution limit, and they're remitting those 1/2 of 1% of those contributions to Connecticut paid leave with the required backup info. So my employers that are here with me, if you have a payroll provider, please ensure that your payroll provider is withholding these contributions and remitting them to us on your behalf, okay? If you're not sure, give them a call and ask. And here at the Connecticut Paid Leave Authority, we receive and reconcile those contributions. We process over and underpayments, and we impose penalties for noncompliance. We don't like to, but we have to. So let's talk about responsibilities regarding claims. So the worker submits their application in timely fashion. They provide their supporting documentation. They update their account with their absence info and information about other sources of income. And we hope, and we're guiding them to notify you as the employer about taking leave and filing claim, okay? So you as the employer, we need you to complete and submit your worker's employment verification form, okay? Notify your worker about your PTO policies, including short-term disability policies, okay? Also, not in here, I think it's on another slide, but I just want to add in, if you have call-in policies, please notify your worker about your call-in policies too. And of course, refrain from discriminating and retaliating against your worker for taking leave. Here at CT Paid Leave, we work with AFLAC to determine eligibility, review supporting documents, and approve and deny claims as appropriate, calculate and pay benefits, investigate potential fraud, monitor ongoing claims, and impose penalties as appropriate. And the Department of Labor hears appeals relating to denials of claims and to penalties. So what do you need to know about FMLA? So let's recap. Reminder, FMLA refers to the laws that provide eligible employees with the right to take job protected leave for certain qualifying family and health reasons. And there is a federal FMLA and a Connecticut FMLA. So let's review that. So am I covered under FMLA? So covered under federal FMLA are employers who have 50 or more employees within a 75-mile radius. This includes governmental entities of any size. So this would be federal government, state agencies, towns, schools, railroads, and governments of other states. Covered under Connecticut FMLA is almost all employers who have 1 or more people working in Connecticut. This also includes the state of Connecticut as to all state employees. So who's not covered under Connecticut FMLA? Well, that's pretty much everyone who's covered under federal. So federal government, municipalities, local regional boards of education, non-public elementary, secondary schools, railroads, governments of other states, and other sovereign nations. So is my employee eligible for leave under FMLA? Let's take a look. So under federal FMLA, if they've been employed by my company for at least 12 months and they have worked at least 1,250 hours in the 12 months immediately preceding the leave, they would be eligible for federal FMLA. For Connecticut, if they've been employed by my company for at least 3 months immediately preceding the leave, they would be eligible for Connecticut FMLA because there is a no hours worked requirement. And you as the employer would make this eligibility determination, okay? So let's take a look at eligibility for job protected leave. So any of these scenarios can be possible. So an employee could be eligible for federal FMLA leave only, or Connecticut FMLA leave only, or both federal and state FMLA leave running concurrently. Neither federal nor state FMLA, but maybe job protected leave as a reasonable accommodation, or possibly no job protected leave at all, okay? So how long is the job protected leave? Well, federal FMLA is up to 12 weeks of leave in a 12-month period for all FMLA leave reasons, as is Connecticut FMLA. So both of these are 12 weeks of leave in a 12-month period for all FMLA leave reasons, okay? And both also accept up to 26 weeks of leave in a 12-month period for military caregiver leave. Big difference here is in Connecticut, okay? An employee may receive an additional 2 weeks of FMLA for a serious health condition resulting in incapacitation during pregnancy. Also in Connecticut, the Connecticut Family Violence Leave Act, up to 12 days in a calendar year, all right? So that's a big difference here is in Connecticut, the extra 2 weeks for incapacitation during pregnancy and up to 12 days in a calendar year for Family Violence Leave Act. So let's talk about the responsibilities regarding FMLA claims. So the worker needs to notify you about the need to take time away from work in a timely fashion, obviously, if the need for leave is foreseeable. Submit an FMLA application as necessary. Some employers have an application, some don't. If you have an application and they need to fill that out, they need to do that. Provide you as the employer with supporting documentation. This would likely be like a med cert, and comply with your employer attendance and call-in policy. So we do have that in here. All right. And you as the employer, you need to establish a leave policy, including rules about your PTO usage. All right. Post your FMLA poster, process leave requests, monitor leave usage, manage your workers' return to work, and of course, refrain from discriminating and retaliating against your worker for FMLA usage. Okay. Now here at Connecticut Paid Leave, we actually have no official responsibilities relating to federal or Connecticut FMLA. We're providing information about FMLA as a part of our CTPL training because they kind of should go hand in hand. We like to think that most folks who want to take leave from work to take care of themselves or a loved one generally want to go back to work. And so when you do that, you need your CTPL to take care of your bills and you need your FMLA to protect your job. So we are providing training about FMLA to go hand in hand with CTPL. The Department of Labor on Connecticut and the federal level are actually the ones who promulgate the regulations regarding FMLA. So for more information, for guidance to workers and employers, we do have the links here. As I said before, you'll get a copy of the deck. You can reach out to Department of Labor for more information. Both of the Department of Labors also do investigate complaints regarding denials of claims and discrimination and retaliation. Okay. So let's talk about the job protected leave process. So the worker is going to notify you that they need to take time off from work if they know that if the leave is foreseeable, as soon as practicable, if it's not foreseeable. And just a quick note, applying for CTPL benefits is not the same as applying for FMLA. That's a completely different process. So I just wanted to cap on that real quick. So you as the employer would determine if the worker is eligible for FMLA. This says CT FMLA here, but in general, FMLA, okay? And you notify your worker that they need to provide any additional documentation. You as the employer, you have 5 business days to notify your worker of their eligibility and provide the notice of rights and responsibilities. This is not the leave approval. So here's the job protected leave process, essentially. The worker is going to provide their documentation to support their leave reason. They have 15 calendar days to give you their documentation. If they're having trouble and they need a reasonable extension of time, they should let you know so that you can provide that to them. You're going to review their documentation and notify them if the leave is approved under Connecticut FMLA or federal FMLA or both running concurrently, whatever the situation may be. You have 5 business days once you've received their documentation to let them know what your decision is. You must notify them if they must use their PTO and when and how to call in. and also if a fitness for duty is required for them to return to work. When the worker reports to you to actually take their FMLA leave, then you need to let them know when they're calling out if they should say, this is my FMLA leave, and you do need to track their FMLA usage against their FMLA balance, okay? And then when you return this worker back to their job, you have to give them the same job they had before they went on leave. You have to. They have that right to return to the same job with the same terms, same conditions. If the worker was out for their own serious health condition and they have some medical restrictions when they come back, you need to consider whether there are any reasonable accommodations you can put into place to enable that worker to perform their essential functions of their job. All right. Remember to tell your employees, when approved for CT or federal FMLA, the attendance and call-in policies that must be followed. Employees need to notify their supervisors when they're taking their FMLA leave, and employees are responsible for providing you, the employer, and CTPL with complete and sufficient medical certifications and documentation significant to their leave. There may be other laws beyond CT FMLA that apply to their situation. We'll take a look at the next slide in a moment. Even if for some reason the employee doesn't want their leave to be designated as FMLA leave, in all circumstances, it is your right as the employer and your responsibility to designate time off that qualifies under FMLA as FMLA leave. So here's some other laws to consider when providing job protected leave. There's federal FMLA, which we've covered for employers with 50 or more employees, the CT FMLA, okay? But then there's also workers' compensation for covered on-the-job injuries and illness, Americans with Disabilities Act, Pregnancies with Disabilities Act, and the Connecticut Fair Employment Practice. So let's go over these scenarios of how some of these things can work. Some of these get fun. I have an incredible coworker who put these together. So we're going to run through some of these. These are going to give us some scenarios on how some benefits work. FMLA can work with employer provided benefits. So we're going to run through these real quick. And we are at 12:28, so we still have some time, but I'm going to try to breeze through them quickly so we have time for questions. So Bionics R Us has 20 employees working in Connecticut. Jamie is a part-time employee who has worked for Bionics R Us for 2 years. She has 6 days of sick leave accruals and 3 weeks of vacation time. And Jamie breaks her leg running with her dog. Is Jamie eligible for job protected leave? If so, under what statutes and when does the job protected leave start? Is Jamie eligible for income replacement benefits? If so, from whom? And when do the income replacement benefits start? Let's take a look. Jamie is eligible for Connecticut FMLA and Connecticut paid leave benefits. She is not eligible for federal FMLA. So let's take a look. From February 1st to April 11th, she has Connecticut FMLA job protected leave. She's not eligible for the federal FMLA. She does have her employer provided PTO, so she's going to use her sick leave accruals from February 1st to February 14th, and then some of that vacation time she has from February 15th to February 21st. And then CT paid leave is going to pick up for her from February 22nd, and that's going to carry her through to April 11th. Let's take a look at another one. I love this one. Acme Industries has 100 employees working in Connecticut. Wai Coyote is a full-time employee who has worked for Acme for 10 years. He has 4 weeks of sick leave accruals and 2 weeks of vacation time. Wai injures his hand on a non-work related fireworks accident and needs to be out of work for 8 weeks. What should he do? What are his entitlements? Wai should notify Acme HR as soon as practical that he needs leave, provide a med cert and other required documents to HR, and ask HR about PTO policies. Wai should also contact CTPL via ctpaidleave.org or by calling AFLAC as soon as practicable and provide CTPL with a med cert and other required documents. Wai is eligible for CT FMLA, federal FMLA, and CT paid leave benefits. He will use 8 of potential 12 weeks of CT FMLA. So we see that running from Feb 1st through March 28th, okay? He will use 8 of potential 12 weeks of federal FMLA. So we've got the Connecticut FMLA and the federal FMLA running concurrently for the full length of his leave. Okay. He will use only 4 weeks of potential 12 weeks of CTPL because he has his sick leave accruals. Okay, so he's going to use his sick leave accruals from February 1st running through February 28th. And then at February 28th, basically March 1st, his CTPL is going to pick up and run him through March 28th. All right. So I'm going to skip this one for the sake of time, but it's going to be in the deck for you. And let's jump ahead to applying for CT paid leave benefits. How to apply. So you can start a claim, or your employees can start a claim by going to our online portal. We do accept applications via telephone as well. Employees are going to need to provide documentation to report their claim, support their claim, and they must notify you as the employer that they're going to apply for benefits, because they're likely going to need job protected leave under FMLA, which they need to come to you directly for to apply. This is a quick overview of what the claims process looks like from the timeline from case creation to final decision. So they start their application, they submit their identity verification, you, the employer, return the employment verification form to AFLAC. If you're not one of those employers that gives it to AFLAC and you give it to your employees, that's okay. But the employee would upload that to their portal. And from the date that the employee submits all their forms to AFLAC, that is when the process can begin. From that date, there is a 10 to 15 day elapse period that all forms have been received from when AFLAC will issue a decision. Okay, so that's truly when the process really gets started on a decision for whether or not the employee is going to be approved for paid benefits. So here are some resources. We have the employee rights poster, a RAC card, employer toolkit, an HR toolkit fact sheet, and the notice of employee rights. All of these are active links that'll take you to color PDFs. You can download, print, share, however you want to utilize those. And for questions about the Connecticut Paid Leave Program, please do utilize our Contact Us portal. We're adding things to that drop-down menu all the time that's going to get you to somebody who's specialized in that question that you're asking, and they will reach out to you to follow up. For questions about your employees' already filed claims, they can log into their portal or they can call AFLAC. And for questions, again, about FMLA for Connecticut or federal, you can reach out to them directly. Thank you so much. So I'm going to go ahead and stop sharing my screen.